Unauthorized signatures. This arises in two situations. First, forgery, and two, agents who act without authority. Generally, when we have unauthorized signatures, it's wholly inoperative and will not bind a person whose name is signed or forged. We do have a couple of exceptions to this rule. In the case of an agent, what can happen that would make the signature operable and then the instrument negotiable? Well, the principal would have to ratify it. So if we had a manager of a store who entered into a contract with a third party, didn't have the authority to do so, if the principal or the owner ratified it, maybe they put their signature's name on it, their own signature's name on it, or approved it, then that's going to be okay. The second exception is when the negligence of the person whose name was forged contributed to the forgery. For example, you write a check out for cash and you don't put the amount and you leave it around in a public place or where there's other eyes or other folks can get their hands on it. Somebody finds it, they write in the amount and they cash it. You may not escape liability if that payment is then later dishonored. I want to note here that the unauthorized signer or a forger is liable to a holder in due course. That person, the one who does the forging, is always going to be liable. Unauthorized endorsements. We've already have the documents, they're made out. If it's stolen or lost and negotiated and transferred to now a holder in due course, what happens? Generally, a forged endorsement doesn't transfer title, so a person receiving it cannot collect. However, when endorsement is forged or unauthorized, the burden of loss is on the first party to take the instrument with the unauthorized endorsement under two exceptions. Before I get to the exceptions, why is that? Because under the law, the first party to take the instrument is in the best position to prevent the loss to begin with. So let's talk about the two exceptions. When the endorsement is made by what we call an imposter or a fictitious payee. The imposter. It's a person with intent to deceive, pretends to be somebody else or an agent for somebody else. They're the wrong person. So a maker or a drawer issues a note or a draft to someone they think is the payee. The imposter then in turn signs the payee's name. So let's look at some examples. James gives Lauren a check for $2,000 for a debt that's owed. Lauren loses the check. Gloria finds it, endorses the check with Lauren's name, and presents it to the bank. The bank dishonors it. Can Gloria collect on the check? No, she can't. If Gloria signs Lauren's name and gives it to Bob for a debt she owes him, can Bob collect on it? And the answer is no. No one after the forgery can collect on it. James owes Lauren, who he has not met, $2,000. Gloria, claiming to be Lauren, gets James to issue her a check for $2,000. Gloria forges Lauren's endorsement and transfers the check to Paul, who is not a part of the scheme. Can Paul collect from James? Yes, Paul can collect from James. Why? Because James is the drawer and in the best position to avoid this loss. What's the difference from the previous example? In the previous example, or in this example, the inducement is to create the negotiable instrument. So the maker and the drawer here is bearing the loss because James failed to detect the scam. The drawer here intended the imposter to receive the instrument versus the other one where Lauren lost the check and then Gloria signed it. Here, James is being scammed and he should have detected it. The other example involves a fictitious payee. A fictitious payee is a payee on a negotiable instrument whom the maker or drawer does not intend to have an interest in the instrument. Basically, it's fictitious. This person does not exist. And it usually takes place in two situations. One, a dishonest employee deceives the employer into signing an instrument payable to a party with no right to receive the instrument. Or two, the employee agent has the authority to issue the instrument and issues a check to a person who has no interest in the instrument. So the rule is the payee's endorsement is valid and employer can be held liable on the instrument to the innocent holder. So for example, Stewart submits a time card for a non-existent employee and the employer issues the payroll check. Stewart forges the endorsement and transfers it to Reed. Can Reed collect from the employer? Yes. If someone issues an instrument to a person who does not exist, then any endorsement in the name of the payee is invalid as long as the person who pays the instrument does not know of the fraud, or i.e. the bank, right? Does not know of the fraud. That's who we're talking about. Warranty liability. Transferers make certain implied warranties regarding instruments that they are negotiating. These rules apply when an instrument is invalid because it has been altered, forged, or stolen. First of all, the wrongdoer is always liable. They can also be arrested. Second, the drawee bank is liable if it pays a check in which the drawer's name is forged. Why? Because the bank has the drawer's signature on file, and they can determine if it matches. The bank, however, can recover from the payee only if the payee had reason to suspect the forgery, or if the payee was the one who did the forging. We have two categories of warranties. We have transfer warranties and we have presentment warranties. Transfer warranties, there are 5 of these, and it's a guarantee made by any person who transfers a negotiable instruments for consideration to all subsequent transferees and holders who take the negotiable instrument in good faith. So what are these 5 warranties? The first is that the transferor is a legit owner of the instrument, that the instrument contains all signatures that are authentic and authorized, that the instrument has not been materially altered in any way, it's not subject to a defense or claim of any party that can be asserted, and there's no knowledge of insolvency proceedings against the maker, acceptor, or the drawer. Violators are liable for the value of the instrument, plus expenses and interests. Transfer warranties flow to all subsequent holders in good faith for the value of the instrument. If the instrument is a bearer paper, the transfer warranties extend only to the first transferee. Transfer warranties apply only if the instrument has been transferred for consideration. Something has to be given. This is not a gift. It can't be a gift. Wiley forges Kim's name as a maker on a promissory note. The note is made payable to Wiley. Wiley endorses the note in blank, negotiates it to Brett, who is a holder in due course, and then Wiley leaves the country. Brett, without endorsement, delivers the note to Fern. Fern, in turn, without endorsement, delivers the note to Rick. On Rick's presentment of the note to Kim, the forgery is discovered. Can Rick hold Fern liable for breach of warranty? Yes, Rick can, because the note is a bearer instrument and Fern is the immediate transferor. Can Rick hold Brett liable? No, Rick cannot hold Brett liable because Brett is not Rick's immediate transferor and did not endorse the note. A presentment warranty is a warranty made by any person who presents an instrument for payment or acceptance. These warranties include for draft Any person who obtains payment or acceptance of an instrument makes the following warranties to any other person who in good faith pays or accepts the instrument. 1, there are no missing or unauthorized endorsements, so the person obtaining payment or acceptance is entitled to enforce the draft. The draft has not been altered in any way. Has no knowledge that the signature of the drawer of the draft is unauthorized. And anyone who presents a promissory note for payment makes only one warranty. I'm the one entitled to obtain payment on it. That's it. They are the holder of the instrument. They're entitled to obtain payment on it. That's the only warranty. Let's talk about the specific defenses. Defenses can bar the collection from persons who would otherwise be primarily or secondarily liable on an instrument. And there are 2 categories of defenses. We have universal defenses and we have personal defenses. Universal defense, it's also referred to as real defense, is a defense that can be used to avoid payment to all holders of a negotiable instrument, including a holder in due course. Universal defenses include the following: forgery of a signature on a negotiable instrument, fraud in the execution, material alteration, a discharge in bankruptcy, minority, illegality, mental capacity, or extreme distress. When an instrument is forged, the person's name who is forged has no liability to pay the holder or the holder in due course. So X forges M's signature on a note and sells it to P. P cannot collect from M whether she is a holder in due course or not. So who is the recourse against? That's going to be X. Fraud in the execution, when we have a person who is deceived into signing a negotiable instrument. This is committed against the signer. The signer believes that they're signing something else other than a negotiable instrument. Maybe they've been misrepresented, somebody lied, they're under duress. This is not going to apply, though, if the person should have known better. A material alteration has to involve something material in the contract terms. So it's material if it changes the contract terms between any 2 parties in any way. The change in interest rate, the amount, the days that they have to pay. So for example, Marx negotiates a $200 negotiable note to Jim. Jim changes the amount to $500 and transfers it to Mark for $500, who qualifies as a holder in due course. What can Mark collect from Parks when it comes due? $200. Other universal defenses, a discharge in bankruptcy. We will be talking about bankruptcy a little bit more detail, but basically in bankruptcy, someone is relieved of their obligation to pay. So if that happens, then they don't have to pay. It's settled. The bankruptcy court has settled it. That could be used as a universal defense. Minority, when a minor could disaffirm under state law contract. In the state of New York, the age of majority is 18. Anyone who enters into a contract who's under the age of 18, they can disaffirm or get out of a contract. They can argue that they are a minor and entering into a contract for a note. That's a contract, and if somebody's 16 when they do that, they can be relieved. Illegality, that's when the contract itself is illegal. It'll be deemed void. Mental incapacity, for example, somebody convinces somebody that has severe dementia to enter or sign a note. That would be a defense. That person wouldn't have to pay. Being under extreme distress or duress could also invalidate any payment. Personal defenses are defenses that can be used to avoid payment to an ordinary holder, not a holder in due course. These include breach of contract or certain warranties, fraud in the inducement, previous payment of the instrument, lack or failure of consideration, and non-delivery. These are the defenses that the holder takes subject to the transfer of the instrument. So the holder in due course is not subject to these, Most of these are our common law contract defenses. Dobbs negotiates a note to Mary in payment for a stereo. Stereo negotiates this note to Art, who qualifies as a holder in due course. That's going to be Art. When Art seeks payment from Dobbs, Dobbs points out that Mary breached the contract by never delivering the stereo. What results? Can Art still collect from Dobbs? Yes, as a holder in due course, he can. The defense is personal to Mary. Dobbs' recourse is to Mary. Breach of contract or breach of warranty, we did this example back in video 1, Joe and the ABC auto lot example. Fraud in the inducement, different from fraud in the execution. Carla uses a promissory note to pay for stock in Sean's company. It turns out the company is fraud. Carla would not have to pay Sean, the holder, but if Sean transferred the note to Peter, a holder in due course, Carla must pay Peter, even though the underlying contract was fraudulent. This is different because in the execution, the instrument is a fraud. The instrument itself is a fraud. Other personal defenses include previous payment of the instrument. Maker of a negotiable note pays on the note but does not keep or cancel the note, and a subsequent party who qualifies as a holder in due course seeks to collect on it, must pay, holder in due course. But the key I want to make, when you pay off a note, be sure to retrieve the note or have it marked canceled or get it back. You will probably get paid in full or something of that if you've got a note with a creditor, loan for a vehicle as such. So lack or failure of consideration. The promissory note of a gift that says, I promise to pay you $100,000, it's due on demand. There's no consideration here, so it's not, you are not, if you're the one who's receiving this gift, you are not a holder in due course. However, if you transfer it to somebody else and you are the holder, they take for value, they have no notice of any claims, they're a holder in due course, it then becomes a negotiable instrument. Non-delivery. M issues a note that is bearer paper. It is stolen by T. T sells it to a holder in due course. Can the holder in due course collect from M? Yes, they can. The shelter rule provides that a transferee of an instrument acquires the same rights that the transferor had. So even if not a holder in due course, if the transferor was a holder in due course, the holder in due course status to subsequent transferees, they can acquire the rights. They don't become a holder in due course. They get the rights of the holder in due course. The holder in due course is said to have washed an instrument so that any holder thereafter can be a holder through that holder in due course. Said another way, when a holder in due course transfers an instrument, the recipient acquires all the same rights. Even if he's not a holder in due course himself, he gets holder in due course rights. The point is to protect a holder in due course so it's able to sell the instrument to anyone. So, for example, a holder in due course transfers a note to Shelton, who knew that the maker of the note has a personal defense. So Shelton does not qualify for a holder in due course, but has the same rights because he is a holder through a holder in due course. Shelton now gives the note to Bob. Bob does not qualify for holder in due course because Bob didn't give value because Shelton gave it to him. But Bob is a holder through a holder in due course. These folks are entitled to payment on demand, just like a holder in due course would be. Pam acquires a check from payee. Neither Pam or the payee qualifies, in this case, as a holder in due course. Pam delivers check to Quan, who does qualify for holder in due course, meets the requirements. If Quan negotiates the check back to Pam, does she acquire the rights? No, her rights remain those of a non-holder in due course. Due to the harsh effects that the holder in due course rules can have on consumers, the federal government continued liability to holder in due courses for consumers who purchased a defective product. The Federal Trade Commission They abolished the holder in due course doctrine for consumer transactions. Under the rule, any negotiable instruments created as a result of a consumer purchase must have the following notice. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods and services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. Basically, in essence, consumers who are parties to consumer credit transactions can bring any defense they have against the seller of a product against a subsequent holder of a promissory note as well. Basically, it places them in the position of a contract assignee, so they can use personal defense. Discharge from liability on a negotiable instrument. How does it happen? There's a few ways discharge happens: payment, cancellation, surrender, agreement, and material alteration. So once a party has paid, all endorsers are discharged from liability. The cancellation of a prior party's endorsement discharges that party from liability. The parties can agree, and of course, any material alteration, forgery. A few other points: oral attempts to discharge are not effective, has to be in writing. Intentional destruction of the instrument by a holder discharges prior parties to the instrument as long as the intent is to eliminate the obligations on the instrument. Accidental destruction of the instrument, as long as the original terms can be established, the instrument's still going to be valid. And my last point is that no discharge is effective against a holder in due course who acquires an instrument without knowledge of the discharge. You don't want to get stuck paying twice, so ensure that the discharge is in writing and any holder or any potential holder is aware.